Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. Today we will discuss Section 8 of Prevention of Corruption Act. Basically, it is concerned with offences relating to bribe a public servant. As far as Section 7 is concerned, in which there might be cases wherein the public servant obtained or accepted or attempt to obtain an undue advantage. But here the situation is different. It is pertaining to offences relating to bribing a public servant. The said section is having two subclause number 1 and subclause number 2. Subclause number 1 says that any person means natural person and juristic persons as well, who gives an undue advantage to another with intention to induce a public servant to perform improperly a public duty. And the same might be as a reward to a public servant for improper performance of a public duty. So for the application of Section 8 of PC Act, it is sine qua non that the person might be a natural person or a juristic person. Inter alia, he gives or promise to give. Element number 3 is that an undue advantage. Point number 4 is that to another person or person, as the case may be, with intention to induce a public servant or to re-award such public servant for improper performance of a public duty. So pendency of work is also must. And apart from that, the element of inducement or element of re-award must be present on record. To understand Section 8 of PC Act, we have to take the example given. A person, Mr. P, gives a public servant an amount of rupees 10,000 to ensure that he is granted a license over all the other bidders. P is guilty of an offence under this section. So now it is clear to us that a person would be liable as per Section 8 of PC Act if he give or promise to give undue advantage with intention to cause the public servant to perform the public duty improperly. And the same might be as an inducement or as a reward. To be noted that the person means include natural person and commercial organization means juristic persons as well. But in case of conviction, the concerned juristic person will be punishable with fine only. They could not be imprisoned. But the person authorized on behalf of such institution when the offence is committed would be liable for imprisonment. To be noted that there is an punishment in case offence is proved. But apart from that, the proviso attached to Section 8 is quite important. There are two provisos. Proviso number 1 says that the said section would not be applicable where a person is compelled to give the undue advantage, but it is on the said person who gives the bribe to prove that he was compelled to give such undue advantage. If he fails to do so, in that scenario he would be liable. And apart from that, to claim the immunity, there must be elements on record as per proviso number 2, which says that the person so compelled must report the matter to the law enforcement agency or authority or investigating authority within a period of 7 days from date of giving such undue advantage. There might be a case where a person could say that Mr. B had demanded rupees 5,000. At that time, I had given rupees 2,000 and recorded the conversation. I was compelled to give the bribe amount. In that scenario, concerned person is required to report the matter to the concerned law enforcement authority within 7 days from date of giving of such part of undue advantage. If he failed to do so in that scenario, we could take this point as a defense strategy to hit the prosecution. So basically it is part and parcel of defense strategy. Apart from that, we have to study the explanation which says that it is totally immaterial that the person to whom the undue advantage is given or promised to be given is the same person who will perform or cause performance of public duty improperly. It is also immaterial whether it is given directly or through a third party. But to be noted that if the person who gives or promised to give the bribe inter alia inform the law enforcement authority, and after that he gives or promise to give any undue advantage to another person in order to assist the law enforcement agency or authority or investigating authority in its investigation of the offence alleged against the latter, in that scenario he would not be liable. So you have to examine your case. If there is a scenario that the part amount of bribe is given and within 7 days the matter is not reported to the concerned law enforcement agency to show that he is competent, or inter alia there is nothing on the record that after informing the agency he gives or promise to give the bribe with intention to help the authority in its investigation of the offence alleged against the concerned public servant, in that scenario the concerned person would be liable and we may proceed as per section 8 of PCA. So we have to understand the legal provisions and protocol. And apart from that, if you are going to contest section 7 of PCA, in that scenario we may take the assistance of section 8 of PCA as a shelter of defense. So all these points are important and relevant as far as the prosecution under section 7 of PCA is concerned. See you in the next video. Till then, Jai Hind, Jai Bharat.